different committee meeting room because some of the Senate committees are having a joint informational briefing today in our regular committee meeting room. And I think that some of our members of this committee are on those committees and are in that briefing today as well. So with that, want to go ahead, as time is running very short in this session, want to go ahead and work some bills that we have previously heard. And the first bill I want to pull up is House Bill 2549. And it has to do with notice for adoptions. And if we could have a brief reminder from the reviser.
All right. Thank you, Madam Chair. Jason Thompson, Reviser, Statutes Office. We're getting some settling in back here at the staff table. Appreciate the patience. 2549 is the bill about adoption. So there are two bills in this, 2549 and then what was originally Senate Bill 115 that is currently sitting in conference with the Children and Seniors Committee and this committee. So the underlying bill deals with termination of parental rights and making sure that a petition filed as part of an adoption has to be connected to an adoption, not just a separate termination of parental rights action. And then the 115 that was placed in this bill as Section 1 deals with notice in adoption proceedings and kind of separates out the different folks who might get notice in independent or step-parent adoptions, public agency adoptions, and makes those requirements kind of clear and distinct depending on which type of adoption action we're in.
Thank you. Committee, any questions for the reviser? Not seeing any, then is there discussion, or I'll entertain a motion? I'll go ahead and move that we pass out House Bill 2549 favorably for passage. Is there a second? Second from Senator Olson. Any discussion on the motion? You all then have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. We will next turn our attention to Senate Bill 415 and a brief reminder from the reviser that has to do with creating the crime of organized retail crime.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. Senate Bill 415 is the one about the crime of organized retail crime. Also increases the penalties for certain kinds of theft. Includes the new crime of organized retail crime in the definition of racketeering activity under the Kansas RICO Act, and then has amendments to the Attorney General's authority to prosecute crimes that are part of an alleged course of criminal conduct that occur in 2 or more counties.
Any questions for the reviser? Not seeing any. I do have yes, I have an amendment. Committee, while he's passing that out, if you'll remember, there was some testimony about the severity level of the penalties that the bill would create. And so this is an amendment brought to us by the Office of Attorney General, and it creates some different provisions regarding the penalty levels, if the reviser could further explain.
Certainly. Thank you, Madam Chair. Jason Thompson again. So this would create some tiered penalties, much like we have in the current law for theft. So you see on page 1, there are 2 new boxes. We make clear that organized retail crime that is a value of $3,000 to $15,000 is a severity level 5 non-person felony. And then if it's 15,000 or more, it's a severity level 4 severity level 4 person felony. That should actually say non-person felony. That's a typo, so please correct that. It's a non-person felony, not a person felony. Apologies for not catching that. Then on page 2, we've got some exceptions to the value amounts there to make the provisions on page 3 work. So kind of technical language on page 2. Page 3 makes clear that property of $3,000, but less than $15,000, that is refunds, money, merchandise from a retailer, right? So that new language that was added by the bill, that penalty will be a severity level 5 non-person felony, matching what was on page 1, right, for the other crime. And then a new category above that for value of $15,000 or more, that's a severity level 4 non-person felony, again, matching what's in section 1. So you would have organized retail crime that would have a 5 and a 4 based on the $3,000 and the $15,000 amounts. And then you would have theft of certain property that doesn't meet organized retail crime, but is similar. That would be a 3,000 level and a 15,000 level that are the same 4 and 5. That's the amendment.
Thank you. Questions for the reviser? Not seeing any, so the amendment does create a new severity level of organized retail crime because the underlying bill has severity level 5 for all levels of organized retail crime from 3,000 or more, and the amendment provides level 5 for 3,000 to 15,000, but a level 4 for higher of 15,000 or more. So with that, any discussion? First of all, is there a second on the motion? Senator Steffen, I saw first. Any discussion? Not seeing any, then I move that we amend Senate Bill 415 with the amendment we have discussed. And you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. No. The motion carries. We are back on the bill. I do have another amendment. And this amendment concerns, there was some testimony that we heard, I think, about the overall jurisdiction that the bill provides. It's addressing that it would be a little bit more narrow jurisdiction. And this, again, also was an amendment brought to us by the Office of Attorney General. And with that, then, if the reviser would explain.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. So this is the one labeled prosecution of specified crimes that you're receiving. On page 8, you'll see that this is an amendment to the final the final substantive section of the bill, KSA 75-702, the powers and authorities of the Attorney General. The proposal as brought to you was to make the authority, to give the Attorney General authority, concurrent authority with any county or district attorney to prosecute crimes that are part of an alleged course of conduct that occurred in 2 or more counties. The balloon attempts to narrow that to the following crimes when they are part of an alleged course of conduct. And it does that by listing the crimes in the box on the final page of the balloon, the attachment A. I won't go through all of those. The list was chosen by the Attorney General's office. You can see it begins with, fleeing and eluding, includes some homicides, it includes some robberies, thefts, violations of the RICO Act, all of those things. So rather than listing RICO and theft, it lists all of these crimes in one list that are part of an alleged course of criminal conduct in 2 or more counties.
Thank you. Questions for the reviser? So I do see that this is a specific list of crimes that would give the office concurrent authority, and The crimes aren't necessarily related to organized retail theft, but it is a more narrow list. So with that, then, any discussion? Senator Steffen.
Thank you. You know, I have talked to my county attorneys and in regards to this bill and a bill from last year, they were very pleased with the idea of having the Attorney General sign on in this capacity. The concurrent authority in particular was very palatable to my county attorneys, so I do support this amendment and the bill.
Thank you. Other discussion? Senator Corson.
Thank you, Madam Chair. 2 points. In response to what Senator Steffen said, I would just note that right now, under current law, county and district attorneys can always bring in the Attorney General if that's what they want to do to help and assist them on any case. So they can still do that, you know, currently, and really whether or not we adopt this amendment or anything similar, county and district attorney can always reach out to the Attorney General and ask them for their help on a case. I'm concerned and I'm not supporting this amendment because, again, I think this is just a very broad grant of a lot of authority to the Attorney General. And we didn't really hear testimony about the need for why that they need concurrent jurisdiction over all of these different crimes. The bill was about organized retail crime. The testimony was about organized retail crime from both the proponents and the opponents. I'm not necessarily opposed to these expansions had we had a hearing about them and had we been able to hear testimony about why they needed to have this additional jurisdiction and why it was necessary. But without that, I can't support it because, again, I just feel like the bill was focused on the organized retail crime aspect, and that's what we should keep the focus on. And if we are going to do a dramatic expansion, which you can see how long this list is. I mean, involuntary manslaughter, vehicular homicide, warehouse receipt fraud. I mean, just a lot of things that really have nothing to do with the core of the bill. I would just encourage us not to adopt this amendment. And then if there was a bill brought later about why the need for some of these expansions were necessary, we could have a hearing and let folks come in and talk about the pros and cons of such an expansion. So I'm not opposed to it outright, but I am opposed to the amendment just because we haven't had a chance to hear testimony about the need for it. I think we should stick in this bill to organized retail crime would be my suggestion.
Committee, other discussion? Not seeing any. Is there a second? Senator Steffen. You all then have heard the motion. Any further discussion? Not seeing any. Then those in favor of the motion signify by saying aye. Aye. Those opposed, no?
No.
The motion carries. We are back on the bill. Yes, Senator Haley. Please record Senator Haley and Senator Corson as noes. Thank you. We are back on the bill. Committee, any further amendments? Senator Corson.
Thank you, Madam Chair. I have an amendment on the similar section of the bill. And Jason, if you could distribute that.
Would you like to explain your amendment?
Yes, thank you, Madam Chair. And Mr. Thompson, please let me know if I explain any part of this incorrectly. But so under current law, we passed Senate Bill 174 last year, and that bill gave the Attorney General's office concurrent jurisdiction in cases where theft occurred in 2 or more counties. Current law, so that is because that passed, that's obviously current law. Current law also gives the Attorney General concurrent jurisdiction over Racketeer Influenced and Corrupt Organizations Act matters in 2 or more counties. And so what I would propose that we adopt is to provide that similar concurrent authority with any county or district attorney to prosecute organized retail crime, and also retain the ability to do that same thing for theft and RICO. So it would basically expand that concurrent authority to include organized retail crime and retain what we currently have, which is theft and RICO. And again, I won't bore you. I mean, my advocacy for this amendment would be the same reason I didn't support the previous amendment, just because I think the bill is about organized retail crime. We should keep it focused on organized retail crime. If there's a need for further expansions, I think that really should be a separate bill that we can hear and have folks come in and give us the pros and cons of any potential additional expansions. So that's the reason I brought the amendment, and that's why I'm hopeful that we can adopt it. Thank you.
Thank you. And a question for the, well, I'll open it up for discussion. Any discussion? All right, yes, Senator Stephan.
I waited till you looked away before I raised my hand. Thank you. You know, and obviously we don't have a ton of time to review these and analyze them down to the minutia, but it looks to me like the amendment we just passed is for all intents and purposes of this amendment plus a little buffer area to really beef out the organized crime aspect of it. So I really think we're just going over the same ground twice and ultimately decreasing the efficacy of what we just passed. So I'm not going to support this amendment.
Thank you. Other discussion? Seeing none, then, is there a second for the motion? Senator Haley with the second. Any further discussion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion does not carry. We are back on the bill. Any other amendments? Not seeing any, then is there a motion on the bill as amended? Senator Stephan.
I would make the motion that we pass Senate Bill 415 as amended favorably.
I'm going to pause right there, and if we could hold on that motion, and we're going to, well, I'll take a second on the motion. If you could, what I'm going to suggest is that we halt our work, and if you'll withdraw your motion, we halt our work on 415 so we can open up a House bill and put the that's a shell, put the contents of 415 into the House bill shell and get it over to the House faster, if you'll withdraw the motion.
Withdrawn.
Thank you. With that, then, we will pause our work on Senate Bill 415, and we will open House Bill 2114. It was a trust bill, 2114, the contents of 2144. Open House Bill 2144. That's a trust bill from last session. The contents have been already enacted into law, so House Bill 2144 is truly a shell. And I will make a motion then, if we are procedurally ready for that from the reviser, to place the contents of Senate Bill 415 as amended into House Bill 2144 and remove the contents of House Bill 2144. Do I have a second on that motion? Senator Stephan with the second. All those in favor signify by saying aye. Those opposed, no. The motion carries. We are then on House Bill 2144. Do I have that procedurally correct? I do. Okay, thank you. As amended. Is there a motion? Senator Stephan. I'm sorry. Well, let's make that a Senate substitute for House Bill 2144.
Senate substitute for 2144, I make the motion that we pass it favorably as amended.
Second from Senator Olson. Any discussion? Not seeing any. All those in favor signify by saying aye. Aye. Those opposed, no. Would you like, the motion carries. Would you like your noes recorded? Senator Haley and Senator Corson. Thank you. I would also like to work House Bill 2632. If you'll remember, 2632 has to do with adding a member to the Law Enforcement Memorial Board. And with that, then, just a brief reminder from the reviser.
Thank you, Madam Chair. Jason Thompson, Revisor's Office again. As you said, this just adds a member to the Law Enforcement Memorial Advisory Committee. That would be a representative of the Kansas chapter of Concerns of Police Survivors, and that person would be appointed by the governor, just like all of the other members.
Thank you. Committee, I'm going to move, if there's no discussion, move that we pass House Bill 2632 favorably for passage, and because it's of a non-controversial nature, we place it on the consent calendar. Do I have a second? Senator Olson. Any discussion? Seeing none, you all have heard the motion. All those in favor signify by saying aye. Opposed, no. The motion carries. I would next like to turn our attention to the three bills that we heard yesterday. And the first one is House Bill 2741. And 2741 talks about the different types of probation and kind of bringing those in line with each other. If we could have a brief reminder from the reviser.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. 2741, as amended by House Committee, does update the general terms of supervision, both for probation offenders and for offenders on post-release supervision or parole. Essentially, it replaces all of the current require the court or the parole board, depending on the circumstances, to impose. And the main difference between the two would be the search requirements. The searches you're subjected to as a probationer are a little different than the searches you're subjected to as, or potentially subject to as a parole or post-release supervision offender.
Thank
That's
you.
probably it.
Thank you. Any questions for the reviser or any discussion? Then I will make a motion that we move House Bill 2741 favorably for passage. Is there a second? Second from Senator Olson. Any discussion? Seeing none, you all have heard the motion. Those in favor signify by saying aye. Those opposed, the motion carries. Thank you, committee, for that. And we are now going to open the hearing on House Bill 2755, requiring compensated sureties who post bond in municipal court to comply with certain requirements, requiring a minimum bond premium in district court and providing reasons for suspending or terminating authorization of a compensated surety. And with that then, a brief bill brief from the reviser. 2755.
Come up here for the bill brief. Thank you, Madam Chair. Normally, you haven't heard from me 14 times, but here we are again. Let's see. House Bill 2755 comes to you from the House. It was introduced in the Committee on Corrections and Juvenile Justice. Actually, it was introduced in the Committee on Judiciary by the Kansas Bail Agents Association. It was referred to Committee on Corrections and Juvenile Justice, then referred to Judiciary, who worked it, amended it, passed it to the House. The House passed it as amended. It looks like 69 to 49. So that is how it comes to you today. The bill, as amended by House Committee, deals with compensated sureties who post bond in municipal court and requires a minimum bond premium in district court, and then provides reasons for suspending or terminating authorization of a compensated surety at the district court level. So section 1 is the municipal court appearance bond section. I talk about current law there, about the municipal judge sets the amount of the bond. Language is added in the bill to require that amount to be the same regardless of the method used to secure the appearance of the accused person. And then subsection B lists all the available methods of securing the appearance of an accused person, and the bill adds execution of appearance bond by a compensated surety to those available methods. The House Committee amendment added some language requiring the approval of the municipal judge for the execution of appearance bond by a compensated surety. And that's similar to the language in the current subsection about execution of appearance bond by a responsible individual. That also requires approval of a municipal judge under current law. So this sort of echoes that current law. Section 2 then gets into the Code of Criminal Procedure. And the first thing it does is it changes the definition of compensated surety. So to only a surety that posts bail for 4 or more persons in a calendar year is subject to the laws governing a compensated surety. It also adds a definition of appearance bond premium, and that means a fee charged by a compensated surety for posting an appearance bond. The bill then adds a subsection B4 that provides the chief judge of a judicial district can require a compensated surety to submit to a state national criminal history record check as part of their authorization in the judicial district. And then there's an amendment related to property sureties. That's more of a clarifying amendment. I kind of go in that in the bill brief, but I'll skip it for now. Subsection D is added so that a compensated surety is required to charge that minimum appearance bond premium that we just talked about of 10%. And then some other requirements about posting only after they receive at least half of the required minimum appearance bond premium and being physically present when the bond is posted and sign the bond at the jail. The House Committee added in subsection D2 requiring a compensated surety to enter into a premium financing agreement for any unpaid minimum appearance bond premium amount. So that's the amendment that they added. Then subsection F, I won't go into all the details, but as amended, it gives a non-exhaustive list of reasons to terminate or suspend a surety's authorization to post bond in that judicial district, and provides authority to investigate violations and terminate or suspend a compensated surety based on one of those violations. And then finally, there's a change in the cap on fees charged for continuing legal education. That's there in subsection G, and I won't go into any more detail than that. It would take effect on July 1st if adopted, and I'll stand for questions.
Thank you. Committee, any questions? Not seeing any, then we do have a lot of conferees on our bills today, so we're going to have conferees limit their testimony to 3 minutes each, please, and so we can reserve time for questions from the committee as well. And please be respectful of the timer. And with that, then, we will invite proponent conferee Katie Wisman with Katie Wisman Consulting. Please introduce yourself and welcome to committee.
Good morning, Madam Chair, members of the committee. Katie Wisman. I appear today on behalf of the Kansas Bail Agents Association. Just as a consequence of time, I'm not really going to go through my testimony. You have my written. I would encourage you to review that because it does include a high-level overview of the bail bond system and kind of how they work and the important role that they play in the criminal justice system by providing defendants access to pretrial release and guaranteeing for the court that they come back for their appearance. The entire system of bail, I want to emphasize, really does balance the rights of defendants with our personal and communal interests in safe communities. So you'll hear a bit more about some concerns with public safety. But I think with the abbreviated time, what I want to do is just address some of the things that you might hear in opposition. So regarding Section 1, this is the piece dealing with municipal courts. I want to emphasize that Article 9 of the Kansas Constitution states, all persons shall be bailable by sufficient sureties except for capital offenses where proof is evident or the presumption great. Excessive bail must not be required. If we were to break that down like we do the elements of the crime, I think there are two very key pieces here. One is that all persons shall be bailable by sufficient solvent sureties, and that bail be non-excessive. So our concern here that we're trying to address in Section 1 really is going to the heart of these two elements, if you will. Municipal courts that are setting cash and professional surety bonds in differing amounts, we believe is constitutionally dubious because it effectively allows the government to detain people while denying them functional access to a solvent surety. The purpose of constitutional bail is to prevent the government from doing exactly what we see here. So we might ask, why is this practice engaged in the municipal courts? Because by their own admission, it incentivizes defendants to use the cash option, which is then retained by the court for the purpose of generating revenue for the payment of fines and fees. The purpose of bond is twofold: to ensure a defendant's appearance in court and to protect public safety interests. It's not, and it never has been, to generate fines and fees or revenue for any unit of government. The other thing, and we believe that's a policy decision for you guys. The other thing, really quick, Section 2, it does establish this 10% minimum. This is not a new concept. There are a number of states that have passed legislation establishing this, which has long been held as an unwritten industry standard. I want to emphasize that states that have done nothing are starting to see one of two things happen. One, they're amending their state constitutions to allow for preventative detention, where nearly everyone stays in jail, or passing legislation driven by extremely progressive national groups to completely eliminate the bail system. In one, the result is denial of pretrial release, and in the other, it is jail overcrowding. So in either case, you have reform that decimates a small business industry in that state. Our goal here is to preserve the right to bail. We believe this legislation is a well thought out and pro-business piece of legislation, solution brought by an association that sees the bigger picture, that represents both insurance and property bondsmen. And I would encourage you to review the written testimony that you've received today that comes from county attorneys, victim advocates, property insurance bondsmen, law enforcement, both past and present. So with that, I'll stand for questions.
Thank you, appreciate it. We'll hold questions till after all the proponent conferees have testified. Next, we invite Shane Rolfe, Kansas Bail Agents Association, to the podium. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. My name is Shane Rolfe. I'm the Executive Vice President and Legislative Chair of the Kansas Bail Agents Association, and I've been a bondsman in Johnson County, Kansas for the past 38 years. I know we have a short time, so I'll kind of just hit the high points here. There's basically two contentious issues in the bills. There's the one that Ms. Wisman talked about earlier as far as the differing amounts, cash or surety. Our position is that there's a constitutional concern there, that if the courts are allowed to set differing amounts, then they can essentially deny someone the ability to use a surety by simply setting that surety bond well beyond any capacity of that person to post, while a much smaller cash bond. The other contentious issue, I think probably more contentious, is this practice of discount bonding that's been going on. Any of you from Wichita area have probably seen this in the news. You've had a series of incidents where people have gotten out on particularly large bonds for particularly violent crimes, and then either the public doesn't understand why they've gotten out or that they've committed additional crimes once they've been out. And I've got some anecdotes in my testimony, and there's been several news articles about that as well, so I'd refer you to those. But we do think this practice of discount bonding is having a negative impact on both the industry and public safety and the image of the industry, the entire criminal justice system as a whole. As Ms. Wisman indicated, this has been done in other states. This is not some new thing that we just dreamed up as a way to create, some sort of price setting scheme for ourselves. At least 10 other states have statutory requirements that bonding companies collect a certain minimum amount of that bond before they can post the bond. Additional states beyond those have regulatory requirements through their Department of Insurance that requires them to file a rate plan that contains both a minimum and a maximum rate plan. And that, like for instance, the state of Indiana makes it a felony for you to do a bond without at least collecting the minimum rate plan that's on file with the Department of Insurance. The one thing all these states that have passed this statutory law have in common is that the bonding companies in all those states have opposed this. They've been, it takes away our flexibility. We don't want to be bound by this. You can't really do this to us. It has never been overturned in any court action. Every court action that's been put against this has been upheld. It's legitimate. It's not a constitutional violation. It does not create excessive bail. This is the first time that I'm aware of that the bonding company or bonding association has advocated for this. What we've seen is this moving this direction in other places. It seems to provide a solution that doesn't involve taking away people's constitutional right to bail while still preserving the bail industry as a whole. And it's our position, though, that placing a reasonable minimum on what a surety must charge and collect prior to posting bail will lower the instances of additional crimes being committed by defendants on bond and also soothe public fears and all these news articles we're seeing about criminals being released with little security. To support this, for those, I'm sure noticed, but I do a podcast on bail issue. I interviewed Jeff Reisig, who's the district attorney in Yolo, California last week, and he did an evaluation of what happened on people that were released on zero bail during COVID compared to the releases that were done prior to that on bail. And what he found was that people released on zero bail committed additional crimes at 163% more times, or more often, than people that were released on bail the previous year, and more importantly, committed new violent offenses 200% more often than defendants who posted bail. So for whatever reason that is, and there's talking points back and forth about why bail works, it does work. And while discount bonds are not exactly the same as zero bail, they're in that same ballpark, and we think they do have an impact on criminal behavior once you get released. So we believe the reason we're seeing more and more of these steps being taken across the country is because of that increase in crime, and we're hoping this can be a solution for that. So I'm open to any questions as well.
Thank you, appreciate that. Next, we will hear from Ed Klump on behalf of the Kansas Sheriff's Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, committee members. I am Ed Klump, and I'm here today representing the Kansas Sheriff's Association, and just to be clear, only the Kansas Sheriff's Association. This bill is one that the association supports, and we've heard from several sheriffs around the state of these issues. I'm going to focus on two areas of the bill and why we believe it's important. One that's been discussed already is the discount bonding fee, setting the 10% minimum. That's a matter that affects victims and victims' families when somebody is released, particularly in a violent crime, with little skin in the game financially on a bond when somebody does a 1% bond. For example, a $500,000 bond, that person could be getting out, with paying $5,000 to get the bond done. But if you look at a $10,000 bond, you're talking about $100 on a 1% fee. And that's a big concern from a public safety standpoint. It's a big concern from victims relating to their trauma and their point of view of their continuing safety in the community with that person out. The second area is the e-bonding. And the thing with the e-bonding is that there's no way to assure when they're doing this electronic bonding, whether they're even dealing with an actual bond agent or not. And so it's important that we think they'd be dealing with a licensed bond agent at the time. There's no way to assure that in this e-bonding. There's no way to even assure they're within the state. So for that reason, some of our counties that were looking at that have opted not to do e-bonding, and we think that's a concern. And there's more information in my testimony, but for the sake of time, Madam Chair, I'll stop there and answer questions when time's appropriate.
Thank you. Are there other conferees wishing to testify as proponents? Not seeing any, then we'll go ahead and open it up for any questions for our proponents. Not seeing any, then want to direct your attention. We do also have proponent written-only testimony from Captain Travis Rakestraw, Wichita Police Department, Dennis Burnt, B&K Bonding, Rick Morey, Morey and Crow Bonding Company, Christian Faisal, Deputy County Attorney, Cowley County, Mark Scheffler, Harvey County Sheriff's Department, Kimberly Salcido, Cowley County Attorney's Office, Luis Salcido, City of Arkansas, yes, City Interpreter, Chase Hobart, Private Citizen, Joshua Libby, City of Sedgwick Councilman, Caden Hayes, Private Citizen, J.C. Lowen, Owens Bonding, Operations Manager, Laura Frisbee, Owens Bonding, Brad Geist, Geist Bonding Company, and Steve Conway, Air Capital Bail Bonds. Do we have any conferees wishing to testify as neutral? Not seeing any, then we will invite opponent conferee, Judge Katie McElhenney. I haven't said that right, I'm sure, from the Municipal Court, City of Olathe. Please introduce yourself and welcome to committee.
Good morning, Madam Chair. My name is Katie McElhenney, and I'm a municipal judge for the City of Olathe. And I'm concerned with section 1 of this bill, specifically the verbiage in lines 13 through 15 that the bonding companies want to have added to the statute. 12-4301 currently reads that a person having the right to post bond for appearance shall execute in writing a promise to appear at the municipal court at stated time and place. Such appearance bond shall be in an amount determined by the municipal judge, period. Municipal judges have always had the discretion on how to set their bonds. By adding the language, and such amount shall be the same regardless of the method used to secure the appearance of the accused person, the bonding companies are asking the legislature to restrict the discretion of the municipal judges. Why do the bonding companies want to do this? Do they really have constitutional concerns? Or is it because the practice of offering lower cash amount bonds, does that cut into the bonding company's bottom line? It's no secret that since COVID, case numbers in all municipal courts across the state have dropped. As such, it is likely the income derived from bonds from those cases from bonding companies has also dropped. So this practice of offering lower amount cash bonds that the bonding companies are objecting to, funny thing, it's exactly what they offer in the district court right now. District court bonds are allowed to be set at 10% OR cash deposit, which means a defendant can post a lower amount cash bond in district courts and be released. And this is on misdemeanors and DUIs, which is exactly what we have in municipal court. So my frustration is that we're trying to change a system that already works for municipal courts, and we're already doing basically what the district court is doing under the statute as it's written. And it's frustrating to have the bonding companies come in and try to undercut that. It's true that the majority of cases in municipal court are fines only. It's traffic misdemeanors, ordinance violations, criminal misdemeanors, many of which are resolved by fines and fees only. And when a defendant posts a cash bond to the court, they know that that bond money is there, so when their case is resolved, they can use it towards their costs and fees or unpaid restitution to victims. And that is a motivating factor for them to appear. So I'm really not understanding the argument that it's somehow unconstitutional to have differing bond amounts. If I set a bond at $250 cash or $1,000 surety, a defendant in municipal court can post a $250 cash bond with the court and we hang on to that money, or they can go through a bonding company. We offer both options. And in fact, according to section 2 of this bill, 10% is the going rate. So somebody can pay $100 to a bondsman or $250 cash to the court. So I'm lacking an understanding of how this practice is unconstitutional. Sufficient sureties are being offered when we have these differing bond amounts. So it's frustrating that this bill is proposed because it's not being offered with the 10% OR cash deposit that the district court has. They want to come in and just have the bond be the same for everything.
And appreciate you wrapping that up, Judge. Thank you. Please stick around in case there are any questions.
I will. Thank you.
Thank you. And next, we will hear from opponent Conferee Greg Nickel, Kansas Municipal Judges Association Treasurer, and he is on WebEx.
Thank you. I think I unmuted myself. You can hear me?
We can, yes.
I appreciate the opportunity. Yes, I am the treasurer for the Municipal Judges Association, also past president for the Court Management Association. I've been in this profession for about 20 years now, familiar with municipal courts from both of those two angles quite well. I do want to start off for those of you who like limited government, we have an extra hurdle to cross when it comes to new regulation. There better be a darn good reason, basically. And if you look at the testimony from proponents, from the sheriffs before, and I've noted this in here, they strongly support this, of course, with felonies, district court matters. And I have no dispute there. Change the bonding requirements there, that no problem. But when it comes to municipal courts, I really question whether there's good reason for additional regulation. In fact, you can look at the video from the House testimony. Representative Vaughn asked Sheriff Easter, said, and I'll read this: would you agree that we really don't have an issue we need to address as it relates to municipal courts? Sheriff Easter: I absolutely agree with that. Yes, sir. So I'm struggling to understand as well why the necessity for additional regulation on municipal courts. Although honestly, I think it is somewhat clear, as Katie mentioned, this protects profits from bail industry, and it doesn't really help anybody else. There was representation that that this just increases municipal revenue, as though perhaps judges benefit from municipal revenue. They don't. There's no per diem or anything. We're not getting paid based on how much revenue we get. The reason for the cash surety is to help defendants. It helps them resolve the case. A lot of these folks, for example, a guy with a driving while suspended, they can be released. We're not worried about them committing a murder because it's just a driving while suspended. If they have a cash bond of $250, these folks often have financial problems that they're battling, and this helps them close out their case, helps resolve it. It is beneficial all the way around. This bill also takes the authority to suspend bondsmen from municipal courts and places it in specifically with the chief judge. I don't know why we would strip that from municipal courts if we've got a bondsman. I'm going to mention this constitutional question. We recently had a commissioned group from the Supreme Court analyze every facet of bonding to see where changes need to be made. And this never came up. I think this is sort of an invented excuse. There is no limitation on their constitutional option. If we've got $1,000 surety and $1,000 cash, cash is not even a real option. How many people have $1,000 laying around? Certainly not our driving while suspended defendants.
Sir, we're at the end of the 3 minutes, so we'll have to have you conclude.
Some of the other folks had 5, but I don't see that this limits it. I think it's an addendum problem, and would ask that you not pass that part of the bill.
Thank you. Are there any other conferees wishing to testify as opponent? Not seeing any, then we'll open it up for any questions for our opponent conferees. Senator Corson.
Thank you, Madam Chair. This is probably for either of the conferees. Can you talk about the ways that the ability to post a cash bond benefits the average citizen, could potentially benefit the average Kansan, and how that's different from posting a surety bond?
Judge, did you want to come back up and answer? Please introduce yourself again. Thank you.
Katie McElhenney, Olathe Municipal Judge. When a defendant posts a cash bond with the court, that money is maintained by the court, and as long as they continue to show up, then they will have that money to be used for any fines and fees if they're found guilty of the charges. If they're found not guilty of the charges, that money is returned to them. But having that money, having that skin in the game is what drives them to come to court. We find that folks that post cash bonds show up for their court cases. Now, when somebody posts a surety bond, say it's a $250 cash or $1,000 surety, the person opts to go through a surety and post $100. And keep in mind, 10% is the minimum that the bonding companies are suggesting. I think it's probably more accurate that they're charging 20 to 30%. So you have a defendant who could potentially be posting $200 to $300 with a surety. And then when they come to court and they say, okay, I plead guilty. All right, sir, this is all the money that you owe on your case. Well, can't I use the bond money that I posted to pay for my costs and fees? Well, no, sir, you gave that to the surety company. You gave that to the bondsman, and that money's gone, and you don't have it now. So now you've got to come up with fines and fees and restitution on your own. So, does that answer your question?
If I may, thank you, Madam Chair. And I would add to that, that if you are innocent or if you're acquitted, then you're also still out that money. So whatever you paid, that 20, 30%, if you are innocent of everything or you're completely acquitted, you're still out that money, right? So, I mean, that's kind of the average Kansan is really out of pocket of that money, where if they put the money up in a cash bond, then they would get that money returned to them 100%, correct? Thanks.
Committee, other questions? I have a question maybe for the reviser about the House amendment to the bill. We've heard that municipal courts currently have authority to set the bond, and did the House amendment address that at all, or could you answer that? Thank you.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. No, in Section 1 of the bill, that's the municipal section. The underlying bill proposes that appearance bond by a compensated surety is an option there in line 29, and the House Committee just added in line 32 with the approval of the municipal judge. So the underlying bill was not changed other than adding that provision in Section 1. The rest of the changes the House Committee made were all in the district court provisions later in the bill.
Thank you. So was there something in the amendment that if a criminal defendant is acquitted, found not guilty, that they could have some of their bond money back, or was that not addressed at all?
Madam Chair, if I understood right, the conferees are talking about how, depending on how you secure your release, that money could be applied by the court to certain costs, and if you use a different option, the money is not with the court and cannot be applied, if I understood right. But the bill itself, the amendment in the bill is equating the different methods, and that's the change on page 1 in line 13 through 15, that the amount shall be the same regardless of the method used to secure the appearance, and then the different kinds of methods that can be used are listed down there in lines 22 through the end of page 1. But depending on which one you use, I think is what the conferees are getting at. It has different results for you about where your money goes and what your money can be used for, or whether you get it back, that sort of thing.
Thank you. Committee, other questions? Senator Baumgardner.
Thank you, Madam Chair. Could we have some clarification? Have the municipal judges consistently been in opposition of this legislation, even prior to the amendment that was made by the House?
Are you asking for opponent to clarify that, or?
I would appreciate that if Judge McElhaney would.
Thank you. Yeah, Judge, please come up and please introduce yourself.
I'm Judge Katie McElhaney from the City of Olathe Municipal Court. It's my understanding, after speaking with colleagues, of course, Greg Nickel, who just testified, but the Lenexa Municipal Court, Erica DeMarco, is opposed to this bill. Jennifer Jones out of the City of Wichita opposed. And mind you, I don't think Section 2 is coming into play at all. It's only Section 1 that the municipal courts are concerned about. So I know that Brenda Stoss from Salina concerned as well. The majority of my colleagues are opposed to Section 1. There's just no need for the change.
Thank you very much, Madam Chair.
Thank you. Senator Bowers.
Thank you, Judge. Thank you, Madam Chair and Judge. If you don't mind, I'm in a really rural area. So how many warrants do you have in Olathe area? Just
outstanding right now, I would say roughly 11,000. A lot of people not showing up for court.
And being from a rural area, do you suppose the municipal judges out in Senate District 36 see this the same way? Do they use this tool? I'm just kind of curious about the difference on the state. I don't see any of my rural folks listed here, so I haven't.
I would think that any defendant who posts cash bond with the court and understands that that money is there for them to utilize once they show up in court and resolve their case, that's what generates appearances in our court. So I can't imagine why it would be too different out there in maybe rural western Kansas.
So then you just went into that. Is cash the only option? Is there?
No, it's always, well, in our court, it's always cash or surety. But I set the bond amounts differently. It's $250 cash or $1,000 surety. You can post $250 cash to our court, or you can go through a bondsman to post some percentage of that $1,000. It could be 10%, it could be 20% or more that you pay to a bonding company. So, does that make sense?
Yes, it does. I might ask that one more. When section 1 that you're discussing, is there any possible amendment that you could think of that would ease your concerns on section 1, or is that just total no-go?
So, I mean, my first thought would be if you just strike section 1, strike municipal courts out of this altogether, that would be the easiest thing to do. We don't have the same discount bond issues that district courts are having. We don't have murders and kidnappings and robberies and rape cases in our courts. So discount bonds are not a problem and not an issue. I have never had an unsecured surety. I think that's the other terminology they're trying to add. I've never had that in our court. I've never had anybody come in and post a surety bond like another person and then not be a professional bondsman. In fact, Shane Rolfe is somebody who I've worked with for years, and he posts probably the majority of the surety bonds in our court. So we've worked together well for years.
Well, thank you, Judge, and thank you, Madam Chair.
Thank you. I have a follow-up question, and then Senator Baumgardner. But you had mentioned that there were 11,000 warrants to have people come up and ensure their return to court. Do you have a percentage of those that are the cash bond option?
They're always cash or surety. We don't do cash-only bonds.
Okay.
We do a lower amount cash and then a higher amount surety.
Okay, and so would you say with the cash option, is that effective at getting people to return to court, or?
It is once they're picked up on the warrant. The trick is that a lot of these folks are from Missouri. They're from Kansas City, Missouri, and so our warrants don't reach across state lines. So until they get picked up on that warrant and have to post it, that's when the effectiveness kicks in.
Okay, so I'm not understanding. When you say it's cash only, meaning the 11,000 warrants, are those people who have already posted some bond? No. They have not.
These are people that have never showed up for court. And I take that back. Maybe some of them had showed up and then not shown up again when they were supposed to. I can't.
But the 11,000 that you mentioned aren't people who have already deposited a bond. Is that correct?
Some may not have. I don't know. There's no way for me to tell how many of those have never appeared in court and posted a bond versus people who have posted and then not shown up.
Okay, so it could be a large percentage, or we just don't know sitting here, so.
I would say the majority, just off the top of my head, from the cases that I deal with, the majority have never appeared in court before.
Okay, they've never appeared, and so then they've never posted any bond at all?
Not a cash or surety bond. They may have posted an own recognizance bond and just signed out and not had to post anything. And those folks are very, quite frankly, regularly not appearing in court. So the own recognizance bonds.
Okay, and then Senator Baumgardner with hopefully a quick question, and Senator Corson with hopefully a quick question. We've got a couple other bill hearings we're trying to do today. Go ahead, Senator.
It is a quick question, but I noticed the question that was posed by the senator here, that Greg Nickel popped up. So did he have a response for rural?
Mr. Nickel, did you have a brief response for the question from the senator from Cloud about more rural areas?
No, I would echo everything.
Okay, thank you. Senator Baumgardner, do you have a question? Senator Corson? No. Okay, great. Any other questions then? So not seeing any, then want to direct your attention to, we do have opponent written only testimony from Erica DeMarco, Municipal Judge, Lenexa, Kansas Municipal Court, Rashane Hamby, American Civil Liberties Union, Kansas, Amanda Stanley, City Attorney, City of Topeka, and Kansas members of the Kansas Pretrial Justice Task Force. Sal Intagliata from Wichita, David Harger from McPherson, Justin Barrett from Colby, Judge Brenda Stoss from Salina. With that, then, we will close the hearing on House Bill 2755 and open the hearing on House Bill 2781, allowing compensation from the Crime Victims Compensation Board to be awarded for criminally injurious conduct and increasing the amount that can be transferred from the Crime Victims Compensation Fund to the Crime Victims Assistance Fund in each fiscal year. And with that, a bill brief from the reviser.
Thank you, Madam Chair. Jason Thompson, Revisor's Office, House Bill 2781. You should have the as amended by House Committee of the Whole version. You should have a bill brief. As the chair mentioned, it allows compensation from the Crime Victims Compensation Board and increases the amount that's transferred from the Crime Victims Compensation Fund to the Crime Victims Assistance Fund each fiscal year. Very quickly, Section 1 amends the statute that lets you apply to the compensation board for compensation if you're injured from a criminal act. Currently, you're allowed mental health counseling as an award. And the main thing the bill does with that category of folks that can get the mental health counseling award now is to remove the restriction so that those same people can get other compensation from the board. So that's sort of big picture what was going on here. The House Committee on Judiciary saw this on 2 occasions, so I'll give you the procedural background that I almost forgot. It was passed out of Judiciary, referred to Appropriations to become exempt for the session, and then referred back to the Committee on Judiciary, which further amended it, and then it was passed to the floor where it was further amended by the House Committee of the Whole, although it was a small technical amendment that our office asked the chairperson to bring that we missed from the committee report. So really all the amendments were made the second time by the House Committee, and then it passed the House unanimously, 121-0. So that's how it made its way here. And the amended version sets a general limitation on claims in subsection B2, and that goes from 2 years under current law, 2 years after the injury or death upon which the claim is based, to 5 years after the injury or death upon which the claim is based. So that's the major change there. 2 years became 5 years. And then the House Committee also added some provisions in B3 that make it clear that if more than one of the time limitations apply to your claim, the victim can use the longest time limitation that applies to them. So whichever is longer, and it essentially would allow more victims to make claims than in theory. Current law in subsection E is expanded to have the board look at the totality of the circumstances and also consider other factors deemed appropriate by the board. So it's a little broader consideration than under current law. The last couple things I'll mention is that there's an amendment in subsection F that adds that compensation may be awarded if the victim obtained a forensic medical examination within 7 days after the occurrence of the criminally injurious conduct. That's in addition to the sort of 72-hour reporting requirement that's in current law. So there's an extra way that you can qualify for compensation added by the bill. And finally, subsection H of the bill talks about the amount that you can receive for work loss, replacement services loss, et cetera. It's current law not exceeding $400 per week or actual loss, whichever is less. The bill increases that amount to $800 per week or actual loss, whichever is less. There's also a provision about human trafficking and aggravated human trafficking folks that they're awarded not less than $350 per week, no more than $800 per week, sort of as a legal creation of what the value of the services might have been, right? They didn't have a loss that they could quantify necessarily, so this gives the board an amount to consider for those specific victims of human trafficking. And then the last thing I'll say is section 2 is the one about the fund transfer. Again, not an appropriation reviser. I can't stress that enough anytime I get the chance. No interest in being one. The fund transfer is $300,000 during each fiscal year currently, and the bill increases that to $500,000 each fiscal year. So more funds will be available for the board to allocate to crime victims. I'll stand for questions.
Thank you. Committee, any questions? Not seeing any. Then we do have 2 proponents on this bill. We have no opponents, so I'll ask each of you to limit your testimony to 2 minutes, please. Kristen Ziegler, Division Chief, Crime Victim Services, Office of Attorney General. And I'm sorry if I didn't say your name correctly. Please introduce yourself. Welcome to committee.
Yes, my apologies. Yes, thank you. My apologies.
We'll start over real quick.
Thank you, Madam Chair and members of the committee, for the opportunity to speak before you today. My name is Kristen Chugala. I am the Division Chief of Victim Services with the Attorney General's Office. And in that role, I also serve as the Director of Crime Victims Compensation. You have my written testimony, so I won't go through everything that is in there today. I do want to stress a few pieces of the bill for you. One is that there is a piece within this bill that addresses a change that is required by federal law. The Fairness for Rape Kit Backlog Survivors Act was passed in 2022, which prohibits compensation programs who receive federal funds from denying a claim for compensation for victims who were delayed in filing an application if the reason for that delay was due to a delay in testing the kit or a delay in identifying an offender through DNA that was obtained through that kit. Our office's assessment is that we would not be in compliance with that statute and with our current statutes, and so a change would be required. And so there is an amendment in here or a change within this bill to provide the board more discretion in approving claims, which would allow bring us into compliance with that federal law. And that change does need to happen before March of 2025. Additionally, the change is to allow the board to approve claims in full instead of restricting to mental health counseling only. That would allow the board to also cover prescription costs, medication management, mileage to and from those appointments, which currently the mental health counseling definition restricts it just to those therapy sessions. Additionally, I wanted to touch on the piece where we request an increase in wage loss from $400 to $800 per week. That was last changed in 1998, so it has been a significant amount of time since the wage loss cap has been increased. Additionally, we are requesting that there be a provision to allow human trafficking victims to receive wage loss. Currently, in order to receive wage loss, we have to document actual loss. That is done through tax returns, through pay stubs, other documents that we have to have, which do not exist in human trafficking cases.
I'm sorry, for some reason the timer didn't ding when it went off, so, but we have reached our 2 minutes.
Yes.
But
all right.
Thank you,
Thank you very
appreciate
much.
that. And next we will hear from Richard Samaniego, Chair, Crime Victim Services, Office of Attorney General. Please introduce yourself and welcome to committee.
Thank you, Chair Warren and members of the committee. Can you guys hear me okay?
Yes, go ahead.
Thank you. I'm Richard Samaniego. I'm Chair of the Crime Victims Compensation Board, and I've served in that capacity since 2018. And honored to do so. I thank you for the opportunity to provide the testimony on HB 2781. I'm not going to duplicate any testimony from our Division Chief, Kristen Chugala, but I did want to give a little background. The Crime Victims Compensation Board is a 3-member board. My other board members are Stuart Height and Becky Dickinson, just so you're aware of their names. We meet once a month. We're meeting tomorrow at the State House, and it is an open meeting. And we close those open meetings to have hearings under the Kansas Administrative Procedures Act. If you haven't read the 2023 annual report from the board, I encourage you to do so. It's helpful, concise information on eligibility in case you have constituent questions. And it's a good resource from that respect. But consistently, when we're hearing claims from victims, the board works with the staff to come up with ways that we can facilitate the processing of claims and make the process better and help more victims. The staff from the Attorney General's Office, Crime Victims Division, is the front line. They help the victims process the claims, and their insight is very helpful for us to come up with the proposals we bring to you today. One of those proposals is the essentially expanding the work loss claims. Last year, if you recall, I came to you and asked for an expansion of the funeral expenses from 5,000 to 7,500. We do thank you for that change. Similar to that, and the cost of those expenses going up, we're asking for the same change to the work loss claims from 400 to 800. The compensation for the work loss for victims of human trafficking is a little different just because they usually do not have financial documentation that we can use to support the claim. So that is a range of 350 to 800, in case you're curious why there was a different amount on there.
Thank you.
This
That is our
legislation-
2 minutes. That is our 2 minutes. So
Okay, thank you.
thank you. Appreciate it. Are there any other conferees wishing to testify as proponent? Any conferees wishing to testify as neutral or opponent? Not seeing any, then want to also direct your attention to proponent written-only documents from Michelle McCormick, Executive Director, Kansas Coalition Against Sexual and Domestic Violence. With that, are there any questions for our proponents? Senator Haley.
I just want to know why it was set at 2 years, the 2 years for, and not perhaps longer. I mean, it's within 2 years of the report, and like, why is it only 2? It seems like it might be longer than that. I don't know if that makes any sense what I'm saying. I mean, 2 years is a good statutory period, but why would it not be a little bit longer considering how long these can drag out?
Yes, please introduce yourself.
Kristen Chagala, Division Chief of Victim Services with the Attorney General's Office. Senator Haley, are you referring to the 2 years from notification to law enforcement?
2 years of the reporting, yes.
Mm-hmm.
Could it, it was less than 16 years, what have you?
Yes.
Would it not be like, I don't know, I don't want to put an arbitrary number, but
Sure.
it seems like there should be a longer period of time. It might be.
Yeah, so that is set for specific cases of child abuse. So it's from the date it's reported to law enforcement. So that could mean that it's 2 years from the date of the crime because they reported it right away. It could mean that it's 20 years from now when they're now reporting to law enforcement that the crime happened. So it's 2 years from the date it was reported to law enforcement. So that's an extended period of time for victims of child sexual assault. There's also an additional provision in there that allows for the board to waive the filing limit in cases where they would find it would be a severe injustice to deny compensation to a victim. So it provides the board discretion to still approve a claim even if it's not within that filing limit.
Good.
Thank you. Other questions? Yes, Senator Stephan, then Senator Baumgartner.
Thank you. It looks like there's 2 or 3 circumstances where the the individual decision-making of the board is being expanded. Do you all suspect that there's going to be a dramatic escalation in payments to folks, or where do you think this is headed?
Thank you, Senator. We do not expect there to be a dramatic increase in applications or expenses. These are very specific cases and situations for victims where the board currently does not have discretion to waive in claims for late filing or general approval. And any additional expenses that we expect to find can be covered with our current revenues. And additionally, we receive a 75% match through our federal grant for any state expenditures that are made. So most of the funding we get back in match dollars.
Thank you. Senator Baumgartner.
Thank you, Madam Chair. So there was amendment action by the House Committee of the Whole. Did you support those? Were those at the request?
Thank you, Senator. Yes, we do support the amendments that were made by the House.
Thank you.
Thank you. Committee, any other questions? Not seeing any, then thank you. And we will close the hearing on 2781. And with the committee's indulgence, so that we can complete our work scheduled for today, if we could briefly have a hearing on House Bill 2601, requiring certain persons on a third or subsequent conviction of driving under the influence to participate in a multidisciplinary model of services for substance use disorders. And we have proponents only listed on this bill, no opponents, so we should be able to conclude our work by noon. Thank you. Go ahead with a bill brief.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. You have a little bit more background in the bill brief. I encourage you to read that at some point. I'll let the conferees get into it. But essentially, I'll give you the procedural. Corrections and Juvenile Justice worked the bill. House passed it 119-0, so unanimous out of the House. It was requested originally by the Kansas Association of Addiction Professionals, and they're here to testify. They're under the old law. Some of us have been around doing DUI forever, it seems like. Before you put DUI on the grid, persons who had a third conviction of DUI went through this multidisciplinary model of services for substance use disorders. When you moved some of those third-time offenders with previous convictions onto the grid, so they're now a severity level 6 non-person felony, and all fourth and subsequent offenders are also on the grid at level 6, that option fell away. It was not carried over to these felony offenders that now go to DOC custody. And so the bill attempts to put that model of services back in place for these third and fourth time offenders who are now on-grid felons, rather than the non-grid felons they used to be long before the legislature changed it. So I think that's all I'll say, and I'll stand aside for the conferees.
Thank you. Committee, any questions? Not seeing any, then we'll invite proponent, conferee, Abraham Fannin Steele, Kearney and Associates, on behalf of the Kansas Association of Addiction Professionals. And if we'll limit testimony to 2 minutes, that would be helpful. Thank you. Please introduce yourself and welcome to committee.
Yes, thank you, Madam Chair, members of the committee. My name is Abraham Fannin Steele, and I'm here today on behalf of the Kansas Association of Addiction Professionals. Jason did a good job explaining the bill, so I won't go into all of that detail. But what I will say is this bill came to our organization's attention late last session, too late to fix a bill. But basically, when you all passed the big DUI fix 2 sessions ago that was brought by the Judicial Council, it, as we believe, inadvertently took this option away from our courts to refer people on their third or subsequent convictions for DUI to treatment. We spoke with the Judicial Council, we spoke with senators and representatives that were involved in that DUI bill, and they were unaware that this was happening. But after the bill was enacted, judges started to tell our treatment professionals that this option was no longer available. So all we're asking with this bill is to revert it back to what we've been doing since 2011. And I think that we can all agree, as our counselors and addiction professionals agree, that if you're on your third or subsequent conviction for DUI, there's probably some sort of substance use disorder at play. So reinserting this language so that KDADs and our team of counselors can work together to find and assess and then treat those that are convicted is really what this bill is getting at too. I invite you to please look at the testimony from Jason Hess and Steve Denny. They're members of our organization that brought this bill forward, and that they talk more about what this multidisciplinary team is tasked with and kind of their process more. But I think this bill is better for Kansans and helps get treatment so that we can get more people back on the streets living in a healthy manner. So with that, I'll stand for questions. Thank you.
Thank you, and we'll reserve questions till we've heard from all our proponents. Next, we will hear from Stuart Little, Behavioral Health Association of Kansas. Please introduce yourself and welcome.
Thank you, Madam Chair. I'll be mindful of the time. Stuart Little, Behavioral Health Association of Kansas, Drug and Alcohol Treatment Providers. I concur with your Mr. Fannin Steele's description and staff's description. This reinstates the right thing that needs to be done for those folks that are in that situation. I'll stand for questions at the appropriate time.
Thank you. Appreciate that. Next, we will hear from Drew Adkins, Behavioral Health Services Commissioner, Kansas Department for Aging and Disability Services. Please introduce yourself and welcome to committee.
Good morning. Good to see all of you all again, Madam Chair, members of the committee. I'll keep my comments brief. We are supportive of the former conferees. One aspect, I won't go over all the testimony. You have that in front of you. Would encourage you to look at the discharge data as well as anything else that was provided by the former conferees. But one thing and a question that we did have on the House side was funding. We do not feel at KDADS, and I think that we provided this in our fiscal note, that funding will be an issue. We have existing funding for these services, and so again, we do not think that this is going to be impacted fiscally speaking. And with that, I'll stand for questions.
Thank you. Are there any other conferees wishing to testify as proponents? Not seeing any, then committee, any questions? Not seeing any, then do want to draw your attention. We do have proponent written-only testimony from Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers Association, Steve Denny, Kansas Association of Addiction Professionals, Jason Hess, Kansas Association of Addiction Professionals, Ryan Batty, Sedgwick County Commission Chairman, Kevin Waring, Chief Court Services Officer, 10th Judicial District. With that, are there any conferees wishing to testify as neutral or opponent on the bill? Not seeing any, then we will close the hearing on House Bill 2601. Committee, tomorrow I do intend to work 7 or 8 bills possibly tomorrow, so please have any amendments ready and please be prepared to work. We will probably start committee with working our bills, and then we have 2 informational briefings. And we will be back in our regular meeting room, 346 South. So thank you, committee members, for your attention and your work today, as well as staff, our conferees for appearing and their testimony, and for those following along in the committee meeting room and online. And with that, committee, the meeting is adjourned.